Good afternoon. Thank you very much for attending this court case update. I'm Claire Shanley. I'm the Executive Director of the American Society of Access Professionals. And today we have Ryan Mulvey and Michael Heise as our presenters. I would like to tell you a little bit about each one. Ryan is Policy Counsel at Americans for Prosperity Foundation, a 501c3 organization. In that role, Ryan works on various legal policy issues, including government transparency at the federal and state levels. He also volunteers as counsel at Cause of Action Institute, where he has specialized in FOIA practice since 2013. As an attorney, Ryan has extensive experience with FOIA litigation and amicus work at the district court, appellate, and Supreme Court levels. As a policy expert, he has advised congressional staff about FOIA reform and researches cutting-edge FOIA issues. In his personal time, Ryan helps run FOIAadvisor.com, a free online resource on all things FOIA. In addition to presenting at many ASAP training events, Ryan has also served as ASAP president since 2021. He especially appreciates ASAP's work to bring together FOIA professionals and the requesting community. Ryan is also a current member of the FOIA Advisory Committee. Michael Heise is an attorney advisor with the EEOC. He processes requests with a focus on sensitive or complicated requests with voluminous records. He monitors the processing agency-wide and reports his findings to the Chief FOIA Officer on a regular basis. Additionally, Michael provides guidance to the field offices in Memphis and San Francisco, as well as agency guidance to his colleagues. He began his career in FOIA as a federal contractor with the Department of Energy in Washington, D.C. Michael serves as Director at Large on the ASAP board since 2021 and has also served on the FOIA Advisory Committee. And with that, I'll turn it over to the ASAP President, Ryan Mulvey.
Thank you, Claire. Thank you, Michael, also for joining me. Before I put on my co-presenter hat, real quickly, I just want to echo Claire's welcome to all of you for this training event highlighting recent developments in FOIA case law over the past year or so. Also, happy Sunshine Week. Sunshine Week started this past Sunday, and ASAP has sort of made it a tradition over the past few years to offer this free, publicly available training on case law updates as part of its honoring of Sunshine Week, its keeping of Sunshine Week. We're also happy to participate in the Breckner Center at University of Florida's Sunshine Fest, which will be happening in person at the Old Museum later this week on Thursday. I will also note, I don't know if you're able to see on your side, but I think we have over 450 people watching this training session, which probably breaks records for ASAP in terms of the crowd that we normally draw for our free online webinars and trainings. And I suspect that this is a reflection on the particularly strong interest at the moment in transparency and in the FOIA. So I welcome all of you who are here today tuning in, both those of you who are ASAP members, who are at federal agencies, or who are interested members of the public, whether within the requesting community or otherwise. Feel free to check out our website, accesspro.org. You can always join ASAP to show your support for our educational aims and purpose, nonprofit purpose. And you can also check out our other training opportunities, which are all advertised there. With all that said, let's get to it. I think, Claire, if you haven't already, we'll be sharing on the Q&A column, if you open that, a link to today's PDF of the case list with cites and with a summary of each case. That's available in the chat, but you can also go onto our website. If for some reason the link doesn't work there, it's available online. Okay. We have two special cases that are not on the list that we've decided to briefly address the kind of the decisions came out after Michael and I had spoken with each other and decided what we were going to present on. So I'm going to briefly mention those, and then Michael and I might offer a few comments, and then we'll jump into our regular programming, if you will. The first of these is Center to Advance Security in America versus USAID. This is a decision from March 11th. And it is a procedural decision. It's not on any dispositive motion, and it has to do with USAID's request to stay processing of the requests that were the subject of the litigation due to the extremely limited number of USAID personnel who were available to work on FOIA matters. Specifically, the agency in its supporting declaration pointed out that since following recent developments in the executive branch and efforts to sort of wind down operations at USAID, there were only 3 direct hire FOIA staff still available and 9 institutional support contractors. And that basically the overall staff had been cut by at least half. The court, one of the striking things that the court noted was that the agency had not actually cited any legal authority for its motion. These sorts of pauses are normally brought under what's called an open America stay, and there are well-established factors that courts have to address. Here, none of that was, it was sort of just a freestanding request that in light of the reduction in force, in light of unexpected resignations and firings and so forth, there were just not enough personnel to continue processing at what had been the regular rate. The court said, as I mentioned, you don't cite any law here, agency, but this is a consented to motion. The plaintiff was okay with the relief that was requested. And because of that, I'll let you, we'll stay proceedings, you'll get what you're asking for, but I'm skeptical that not satisfying the normal open America factors is really enough. That external impediments like lack of funding or unanticipated increase in the volume of requests, those sorts of things aren't relevant here. You just have a reduction in force, and I'm suspicious that the executive branch can sort of try to bypass its FOIA obligations simply by eliminating FOIA staff. So don't take this, the court warned, as indicative of how I would rule in the future. My suspicion is that we will see more requests like this coming from agencies. But I think it's important if you're on the agency side and you're thinking about this, just be careful. Maybe it's better to move for the open America stay or try to find a little more legal authority to ground your request to stay proceedings. Because if it's opposed and you're before Judge Moss, at least, you may not be able to get that, that pause. Michael, did you have anything on that one that you wanted to add?
Well, I think that it's, you know, for folks on the agency side, I mean, that's, it thus far, it's an interesting proceeding, you know, insofar as, you know, it reflects, I guess, a bit about how important, for every agency that's subject to FOIA, that how important, you know, those and real, the FOIA is a part of the mission of every agency that's subject to the FOIA. I mean, that's the statute is written in such a way that it really becomes part of every agency's mission. And I think it's you know, and the issue, and there's a case that I'll be talking about later today, but about, you know, what is a court to do in a situation where the agency is primary argument is, you know, well, there's a lack of resources, you know, and there's a case that I'll be talking about in a different context, but an agency presented roughly the same kind of or found itself in the same kind of well, not the same kind, but in you know, in a position that had to do with some resources. So it's an important and interesting proceeding in that regard, and it's a reminder for me, at least from the agency side, of how important it is for every agency that the FOIA is part and parcel of the mission of that agency. So
Yeah, regardless of whether you're a FOIA officer or not, right? It
Right.
should be everybody's. And I think that's all well taken. The other case, which I suspect many of our viewers are even more interested to hear about and might have on their mind, is Crew versus Doge, or Citizens for Responsibility and Ethics in Washington versus U.S. Doge Service. Crew was very creative. It was the first requesting organization to get a lawsuit in a federal court, basically to try to argue that President Trump and Elon Musk's Doge service is subject to FOIA. As designed, the Doge is supposed to, on the White House's view, be subject to the Presidential Records Act and therefore not be an agency for purposes of the FOIA, 5 USC 552. The Crew filed its request with a request for expedited processing, which triggered an earlier deadline for response from the government. And because that response wasn't forthcoming, Crew was able to get into court after 10 days. And it included with its complaint a request for preliminary injunctive relief. Effectively, what Judge Cooper in the DDC argued, or concluded rather, excuse me, was that it was likely to be the case that Crew would succeed on the merits of arguing that Doge was subject to FOIA and that it was in fact an agency. And accordingly, he ordered Doge to respond to Crew's request effectively now. The government, personally, I did not think that Judge Cooper went too much into the substance of the case law on what constitutes an agency within the executive office of the president. There's been a lot of case law over several decades that has developed. And I think the government felt that way too, since on last Friday, on the 14th, the government moved for reconsideration. And interestingly enough, in the preliminary injunctive briefing, the government really didn't argue at all about whether Doge was subject to FOIA. They kind of relegated that issue to a footnote. And now the government has come back and argued that it has offered that more extensive argument, and it has suggested that Judge Cooper was wrong to basically provide the injunctive relief that he did for a number of issues that really aren't important here, or really are matter for the question of what constitutes an agency within the EOP. I would just point out that the standard, and we won't get into application because I think there can be disagreement and there's going to be really interesting briefing about this, but the standard for when something within the executive office of the president is subject to FOIA is basically, first, does it possess any substantial independent authority apart from the president? Does it exercise any specific functions that aren't grounded, usually that are grounded in a statutory basis? So if Congress has told, for example, OMB to do something, right? So that's one factor that's considered. Another is its function solely to advise and assist the president? And then the DC Circuit, for its part, has set up a 3-part test, 3 factors that look at how close operationally is the entity in EOP to the president himself, what's the nature of its delegated authority from the president, and how is it actually structured and how does it work? Is it a self-contained structure? And the government's basic argument is that Judge Cooper really didn't pay close enough attention to the executive orders here or how Doge is actually structured, and basically confused the Doge teams and agencies, which would be subject to FOIA but are not part of the White House, with Doge within the White House. Now, I would just say, before I hand it off to you, Michael, for comments on possible impacts here, I don't necessarily fault Judge Cooper entirely. I don't think it was appropriate for him to do his own, to look at anonymously sourced news articles about Doge. and the DC Circuit in other FOIA cases about EOP, such as Meyer v. Bush, has actually suggested that that's inappropriate. But the government didn't offer any evidence. Really, there was not much in the factual record for the judge to go off of, which is why I think it'll be really interesting to see how things develop in the briefing and what arguments we might find both sides posing. Do you have thoughts, Michael?
Well, what I guess I'll say is that what's I think interesting, at least to me, and maybe there's folks on the agency side that are thinking about this too, but whether or not that entity that is subject to FOIA or not, what is what is the proper procedures or practices that agency FOIA processors should take when confronted with certain communications that are coming from an agency and going to for example OMB, and does that are, and I don't know the answer to this, are agency FOIA processors thinking about a consultation sort of process with respect to those kind of equities, or are they doing something different, and how is that working? Is that going, are those workflows in place or in process of being implemented, or will evolve over time? Those are just things that occur to me in terms of just how agency FOIA processors might be dealing with the kind of equities that are being generated presently. So that's the only thing that kind of comes to mind. I get that agency folks may not want to talk too much about it, but it's just something that occurs to me in terms of what, if anything, do you do in terms of that? Is a consultation something you do or not do? That's about it.
The other thing that I would kind of flag as a possible issue down the line, particularly if the court's decision here or the DC Circuit, if it gets appealed, is that DOJ is not an agency for purposes of FOIA. If that is the case, I think even though the DOJ teams at each agency are and should already be subject to FOIA, even on the government's view, communications between the agency and specifically the DOJ team and the upper leadership, political leadership in the front office of agencies with the White House, you may see the White House try to treat these records as presidential records. We've seen in the context over the years, for example, of Congress and committees communicating with agencies, an attempt by Congress to assert control over the records of communications and to say, look, when you respond to our email, you're creating a congressional record that's not subject to FOIA. And Congress has done that intentionally in order to try to prevent records that, because remember, Congress isn't subject to FOIA, right? To treat records of those communications as not available to the public. And I think you could likely see the president try to do the same thing. And this has happened in the past, both on the Congress side. There's a lot of precedents that are relevant there, but also on the White House side. I mean, visitor logs is probably one of the more litigated examples that I'm talking about, where you have memorandums of understanding or other letter agreements between the White House and an agency to treat certain records as not subject to FOIA, even if they would, under normal control tests, as we call them, whether they should normally be considered an agency record. So these are going to be really interesting issues, both for those on the agency side and on the requester side. And I expect there will be a lot of interesting case law. So for next year's Sunshine Week, we'll probably have a few DOJ cases. Okay, let's jump in to our regularly scheduled programming. The first case that we have is Campaign for Accountability versus DOJ. This is one of a case about reading room records. So here, the requester, Campaign for Accountability, had sought copies of all of OLC's written opinions resolving interagency disputes. And they argued that these particular types of OLC opinions, this subset of OLC opinions, was subject to FOIA's proactive disclosure requirement, 552A2, and that all of these records should be posted to the electronic reading room online without the need for a FOIA request. The background context here is lots of litigation over the years by open government groups wanting to get OLC opinions out there into the public light in a very comprehensive way. The court agreed with the requester that at least this subsection of OLC opinions are indeed subject to the reading room, both as final opinions made in the adjudication of cases, as well as statements of policy and interpretation which have been adopted by the agency. So with respect to the first of these categories, the court said, look, the OLC opinions that are resolving these interagency disputes are treated as controlling by OLC and by the agencies that are impacted by the opinions. So there's a sort of final legal effect that the opinions have. And so therefore they count as final opinions. And they also include the adjudication of cases, because here you have two agencies that are in dispute with one another, and they're coming to the court, to the OLC, and they're asking for a resolution, and OLC is providing that. The problem here with the reading room provision is that, and there's a split in the case law that continues to exist, is that even if you as a requester can show that something qualifies for proactive disclosure in the reading room, the relief that you can get is limited to yourself. In other words, I can't go to court, at least in DC, and get a court to order the agency to post something online. Instead, I can get a prospective injunction, so a forward-looking order, that the agency give me everything that ought to be posted online. Now, the Ninth Circuit in California and the Second Circuit in New York have taken a different approach, and they have said, we courts have the authority, the remedial authority, to order the agency to put something online, to publish what should be in the reading room. So we'll see how that resolves. But very interesting here, big win on the OLC opinion front for those, at least on the non-government side. But we still have that weird thing in DC where the courts won't order compliance that benefits the world, only the injunction that benefits the requester.
Okay, and then the next case is the Institute for Energy Research and versus the Federal Energy Regulatory Commission, or FERC, and that has to do, basically the takeaway with this case is the definition of a record. In the context of this case, it had to do with text messages. So in this case, the requester, and I'm just going to read a little bit of what the request was. It's in the opinion. The requester sought copies of all text messages, including, there were two parts to the request. Part one said all text messages, including anywhere one or more of the words FERC, GHG, FOIA, and or methane. So that first part was all text messages where one of those four words appeared. That was it. And then the second part of that request was, or all text messages that were sent to or from one of six named individuals at the White House. So the court here held that, well, actually before that, The requester also included, part of the request was some language defining what they meant by, by text message in the request. They said, please consider us responsive entire email threads containing any information responsive to this request, regardless whether any part of that thread falls outside the cited time parameters. So what the court here did was they first, what the agency did is the agency construed the request as part A, the first part, as a request for specific text messages, not a string, not a chain, anything like that, because the requester was specifically asking for those text messages where that one of those 4 words occurred. The second part, all text messages sent to the White House, well, there were no records for that. So that's kind of like, that just kind of went away on a no records disposition. And so what came up in litigation here was that the requester said, well, no, we don't want just the text messages that where one of those words occur. We want the whole text string. We want all the text string. And what the court here found was that the agency's interpretation of the request was appropriate, in that they looked at the they first said that, of course, as we all know, agencies basically define a record when they're searching for responsive records, because the FOIA doesn't in itself define what a record is. And so the guideposts that agencies have is, reasonableness standard. For example, an agency cannot just change their definition of a record midway through litigation. They also cited to DOJ OIP factors, which the court highlighted two of the 6 of those factors: the requester's intent and the scope of the request. And then, of course, they also recognized the AILA case, which we all know set kind of a minimum bar, at least in the case of emails, for what cannot be, or for a minimum bar for what cannot be considered. Agencies can't just kind of find a single sentence or something and render that non-responsive. They have to kind of take the whole record as it is and figure out an exemption that would apply, or release it if one doesn't. So the court covered all that, and then they recognized kind of the tension that, I know all FOIA processors have to grapple when they're reading a request, is on the one hand, a duty to construe their FOIA request liberally, and then also the expectation, the reality, I guess, that's reflected in court cases, that FOIA requests need to be read as drafted, not as either the agency or the requester might wish it was drafted. And so what this comes down to is the court said, look, there's nothing for Part B of the request, but since Part B of the request talked about all text messages sent to White House officials, the court said maybe if there, essentially they said maybe if there were records, that would be, the agency would have to look at that as text strings. But there were no records, so there was almost like nothing really to talk about there. But with the first part, where there were records, the court said, look, the requester here might have had drafter's remorse. That's a phrase that the court used. The requester might have had drafter's remorse when it was very specific and intentional when it asked for text messages that had these words in it, and then again not defining when they said they were interested in email chains when there were no email chains, that they were interested in text chains. So the court said, maybe if the request was written differently, maybe it would have had a different result. But there was nothing in the 4 corners of the request, as fairly read by the agency, to mean anything more than specific standalone text messages. But the court also said, I think this is one of the reasons why the case is on presentation today is because the court spent a little bit of time talking about, well, what is the fundamental feature of text messages? And so whether or not this is something that is true at all times or not, here's what the court observed. Unlike email threads, which tend to contain a natural progression of conversation on a unified topic, a text message thread captures the entire conversation history between two people with no subject lines or discrete chains to demarcate new topics. So that was basically the court recognizing that text messages are a bit of a different animal than, let's say, emails and the things that we're more commonly used to, although texts are becoming more common. And what was interesting to me on this is that the court also said that the requester did not alert the agency that it wanted entire text threads. In the section defining information sought, the requester instructed FERC to consider as responsive entire email threads. Well, of course, there were no email threads. And so the court says that, it could have uses language saying it could have the requester could have had their request say, well, we want text messages that are about or concerning or pertaining or related to these 4 words. And maybe that would have disallowed the agency to throw up their hands and saying, well, we have, we're not sure whether you mean a text string or not. But what I thought when I was reading that passage is that would a request that says, I want text messages that are about or related to or pertaining to these, 4 certain words, would that create a reasonably described request issue? Because there are cases, where that becomes an issue where how is an agency supposed to determine what is pertaining to or about something? So, but nonetheless, that the court found that the agency was appropriately defined the record in that case. And I guess the takeaway for requesters, I suppose, is I see this, and I think a lot of agency people see this, is that requesters, even the really sophisticated ones, might submit requests without realizing that maybe portions of their requests are closer to boilerplate than not. And they should think about that, because if agency sees what we mean by this request is email messages, but there are no email messages, there's text messages, that might present a problem in terms of the agency actually maybe doing what the requester may have wanted in their head to have happen, which is to account for all text message strings and email strings. But that didn't happen here. That's it for that. Thanks.
Yeah, I would just add to that. I mean, I agree that I think the outcome here was correct, but that I would be concurring in the judgment, but provide my own reasoning to get to where the district court got. I don't think that, I think the problem here was the requester's framing of the request. It was their omission of any description of wanting more than specific text messages. I would only just add as a final wrap up on this case that, and I'm partial because I've personally litigated this for years, post AILA, and I don't like OIP's guidance. No offense to anybody from OIP who's watching. Your post AILA guidance is wrong, and I obviously have very strong views about what a record is supposed to mean under the FOIA, and I insist that it has to be an objective definition, and this continuum to rely on old scoping approaches and the Privacy Act, or looking at, defining the record as you're processing the text messages in this case is problematic. Text messages are particularly difficult, though, I'll admit, because it really depends. I mean, some agencies do a really good job at recording text messages, some don't, right? So there might be, and this gets to maybe the broader point about what is a record. In my mind, it really depends on how it's being stored. how are text messages stored, accessed, and exported for FOIA requests. If you're an agency that saves text messages individually, like somehow the BlackBerry server, if you go back to the old days, I don't think anybody has a BlackBerry anymore, but if you go back to the old ways, where messages were individually saved and retrievable, that's your record, right? The .msg file or whatever it is that ends, right? The file type. But if you're an agency, and I know some do this, where text messages are saved through screenshot, right? So somebody who's doing the texting screenshots and then forwards it to their email or forwards it to a record keeping system. I think the screenshot is the record, not the individual text messages. And if you're in a world where you're saving screenshots and that's what you're retrieving for the FOIA, you shouldn't be treating each of the lines in the screenshot as a separate record. I mean, that's my view at least. But I'm not on the bench, so I don't get to write the opinions as much as I would like that. Okay, next case, record creation, another issue that has really been popping up in the courts lately. The case we have is Gelb versus DOD, and this is just kind of an example of, again, something that a similar fact pattern to what we're finding in courts across the country. Mr. Gelb, Bernard, if I may call him by his first name, was something of a private investigator, and he helped people retrieve monies that were owed to them. And here he sent a FOIA request to DOD and its Defense Finance and Accounting Office. I guess he had some clients who had a sneaky suspicion that DFAS had a practice of automatically canceling checks after 6 months if they weren't deposited or cashed. I thought most checks were automatically invalid after 6 months or so. So I don't know. I don't know what Mr. Gelb was thinking was so suspicious about what DOD was doing. But he sent a FOIA request to DFAS asking for a report from their procurement database that listed out all of the stale, outdated, and undeposited or uncashed checks. But he also specified that he wanted that report to contain 8 categories of information. Things like the check number, the payment date, the recipient, their address, the amount, invoice number, all this sort of thing. And then most importantly, whether or not the disposition of the check, whether it was still outstanding or not. And what DOD was able to argue successfully was that, look, we don't have a report that contains all that information. And we don't even have all that information in one database. Like the requester had specified a particular procurement system, and they went there to that system and doesn't have all the data points that he's looking for. In order to fulfill the request as the requester described it, the agency would have had to gone to, I think it was 8 different databases and pull different reports and take those data points and construct something to give to the requester. And the court said, or rather the agency said, and the court agreed, that that constitutes record creation. And the FOIA only gives a person the ability to request existing records. You can't send a FOIA to an agency that asks for information to be created. You can't just, it's not like you're deposing the agency or sending a demand the way Congress might do. You can only ask for records, reasonably described records that exist at the time of your request. The court acknowledged, and again, we've had interesting cases. If you go back to any of our past case law development presentations, there were some interesting cases in the Second Circuit with ACLU Immigration Rights Project versus ICE, and in the Fifth Circuit with Rutilla versus Department of Transportation, that dealt with this really fine line between record creation, which isn't required, and the obligation to go into your databases and export information that doesn't already exist in an exportable format. In other words, if you have entries in your database that aren't already there as a PDF, but which can be retrieved even with minimal programming or coding on the part of the agency, that's okay. That's not record creation. But it's something different when you're not just pulling something out of the database, but you're rather taking together different database information and putting it together into one record. FOIA doesn't require you as an agency to do that, and FOIA doesn't allow you as a requester to seek that sort of information.
Okay, and the next case is Cox versus Department of Justice, and this is I think this case is pretty straightforward. It basically is a case that reflects a very clear, I think, set of facts that reflect when Congress has intended that a record it's created is a congressional record and has given no, authority whatsoever for the agencies to kind of deal with that document in a way they see fit. That's basically it. And so what happened in this case is that the requester was seeking a report that was prepared by the United States Senate Select Committee on Intelligence concerning the CIA's post 9/11 detention interrogation program. But what's reflected in the opinion is how this report the requester want came to be, and what happened, and that history of how the report came to be is kind of evidence of the congressional record. And so I'll just kind of quickly say what happened here. And the Senate first asked the CIA for millions of highly sensitive and classified documents. Okay. And so then the CIA sent the committee a proposed memorandum of understanding where the Senate staff would be required to review the documents in the CIA reading room for that purpose and prepare all the material on a CIA-approved standalone computer system in that reading room. The Senate then countered, in part, I guess, they were just kind of hammering out the logistics, I think, of this, when they said, well, okay, it's fine with the standalone computer system, but we want to have a network drive that's only for Senate staff where access to that by CIA staff was restricted. And then they said as well that the ownership of the material generated on that system was information that was exclusively a congressional record and not subject to FOIA. I mean, so they say, and the court lays this out explicitly, the property, the anything in that system, including this report the requester was looking for, is the property of the committee and will be kept at the reading room solely for secure safekeeping and ease of reference. These documents remain congressional records in their entirety, and disposition and control over these records, even after the completion of the committee's review, lies exclusively within the committee. As such, these records are not CIA records under the FOIA or any other law. So, I mean, how clear do you want it, right? And so with that, the court was pretty easily able to conclude that what the requester was asking for, even though the Senate transmitted reports to the CIA and other agencies, that was a record that was not subject to FOIA, was a congressional record. There was a bit in the opinion where, because the plaintiff was arguing, well, then Senator Feinstein, who was heading the committee at one point and then was in the minority on that committee, she had written letters to then President Obama saying, well, we think this, FOIA should apply here or should be disclosed. But basically what the court said to that was, look, she was speaking in the capacity at that moment is as a minority committee member, certainly not for the committee as a whole. And so the court said, the congressional intention here was absolutely clear, and anything that was said post that by someone in the minority did not vitiate that congressional intention. And so the agency it did not have to release that record, which was not a congressional record, as the court held.
Yeah, and folks, take a look at this case, pull it up, and look at the cases that are cited, because these will be really relevant to this. As I mentioned before, efforts by one branch to treat another branch's records is not subject to FOIA. Meaning, like, if the president or Congress try to ask agencies not to treat something subject to FOIA, this modified control test is what really is going to be most important. Okay, we'll try to speed things up a little bit since we spent a lot of time talking about the extra cases at the beginning. The next case is National Security Archive versus Central Intelligence Agency. And I don't know if we have Nate Jones from WAPO in the 635 people watching this, but if not, he wrote a book about what this case is about. So pull up Nate Jones's book about Able Archer 83. So Able Archer 83 was a NATO exercise. NATO decided to do a bunch of military stuff right on the border with the Warsaw Pact, and the Warsaw Pact got, the Politburo in Moscow was like, oh, are they about to start a war? And so they loaded some nukes onto planes and sent them into the air. And then NATO was like, oh, do we respond? Do we escalate? We're just doing a military exercise. And a Lieutenant General, what's his name? Leonard Pirutz. He wrote a report to kind of calm down things and said, no, they're just reacting because they don't realize we're just doing an exercise. And so we didn't take anything further. We averted war, and we're all here so many years later, still alive. So there was a memo that was written, right? The State Department, years later, published as part of its anthology of foreign relations documents a transcribed version of Pirutz's Able Archer 83 memo. But importantly, it was redacted. It wasn't a complete, undisclosed version. It had a line in there saying, "Thank you, CIA, for helping make our inclusion of this memo in the anthology a possibility." I'm paraphrasing, of course. So the National Security Archive at GW University filed a FOIA request with the CIA. And long story short, one of the arguments they made was that the official acknowledgement and public domain doctrines apply here, and the CIA has effectively waived its ability to use any exemptions because a copy of this memo, at least a version of it, has been published by the State Department. And what the court said was, well, not so fast. We've looked at some ex parte in-camera declarations from the CIA, and they have told us that they had nothing to do with the State Department's decision to publish a copy of the memo. And because they weren't part of the disclosure decision, their own decision as the CIA to withhold and to apply exemptions has not been waived. Because remember, under the official acknowledgement doctrine, one of the requirements is that there be official and documented disclosure by the agency that would otherwise have asserted the exemption. So State Department did something, that doesn't tie the CIA's hands, and there wasn't significant enough evidence to overcome the CIA's secret declarations. I would just add that I am suspicious whether the doctrine would have applied anyway, since it was not the exact same memo they were looking for. There was a transcribed and redacted version that the State Department had published and not a fully unredacted one. So the best you could have gotten was what the State Department had already released. The final note is that the court here, the DC Circuit, cast some doubt on there being a distinction between the public record doctrine and the official acknowledgement doctrine. So the idea that, say something is on a court docket, a FOIA requester could argue, without having to meet all of the three factors that are part of official acknowledgement, that is a public record. It's already out there, disclosed to the world. There's an effective waiver there of any exemption claim. The DC Circuit seemed to think that this divergent line of cases is improper, that the factors for official acknowledgement are the factors, and they need to apply all the time.
So the next two requests are cases are for have to do with reasonable description, unduly burdensome issues. It's first is Wright v. FBI, and the other is Freedom Coalition of Doctors for Choice versus the CDC. And I'll go through each of these quickly, I hope, but the kind of the takeaway of between these two is it every request really is different, right? That's what folks say in the in government all the time. I'm sure requesters have heard that too. And in basically in the Wright v. FBI case, where, and I'll explain this in a second, the court found that over 1 million records basically was indicative of a unreasonable kind of burdensome search for the FBI to process. But then in the other case, the Freedom Coalition of Doctors for CDC, 7.8 million responses was not burdensome, and the agency did have to process, and on an expedited basis as well. But taking each in turn, and I'll be really quick, I think, on the Wright case because, well, for one thing, it's only 3 pages long, the opinion is. The requester wanted from the FBI all records discussing mosques in 6 distinct categories that the requester identified. Basically, what the FBI did was they conducted a search on their records repository that's known as Sentinel. And what their Sentinel search found was that if they plugged in the word mosque standing alone, just the word mosque, they had 1,062,851 hits. Then there was some back and forth between, I guess, the court and during litigation with the requester, plaintiff, and the agency and the court. And what the FBI did was use Sentinel to conduct a Boolean search. So mosques and another connector. It's unclear which one in the opinion they used, but that actually turned out to have more hits, 1.8 million. And that was because some documents will hit across multiple records, which I think all of us that conduct searches know that's absolutely the case in a lot of situations. And so what happened here is that basically what the court here recognized, I think, is based on the FBI's efforts and the actual work that they did in conducting these 2 searches to kind of indicate what the kind of gravity of the processing we're talking about here. For example, the search for just mosques would have been about $2.2 million in terms of search hours, calculated around $25 an hour. And then doing the Boolean search was $3.9 million. Kind of all of that in total, the court found, and again, in this brief opinion, that the FBI the FOIA did not require the FBI in a situation like this to process that request. On the other hand, there is another case, and that is the CDC case I was just talking about. But this one, I think, every request is different. Is I guess the theme for these 2 that I think is applicable, and that is in the CDC case, what the requester was looking for was basically these free text responses that were housed in an application, like a smartphone app called VSafe. And the VSafe application was designed by the CDC to basically allow folks who had gotten the COVID-19 vaccine to kind of report their symptoms via the app kind of in real time. There was 2 parts of the VSafe. There was check the box options. There was the free text response. This request was about the free text response. The free text was a lot like Twitter. You could write whatever you want, but you can't go more than 250 characters. And the requester wanted all of those free text responses. So what the agency said was, look, there are 7.8 million responses. And because it's a free text, there was what the agency called unsolicited PII within those characters, right? Like a social security number someone put in, or this or that or the other. And so the agency, and this kind of goes to what we were talking about in the beginning, the agency's, I mean, basic argument, was that they just didn't have the resources to conduct a segregability analysis of 7.8 million responses. They did withhold all of the free text responses from the requester, is what triggered the litigation, and that was their position. Is that, like, look, we can't engage in this in this B6 analysis. And so what the court there found was, and the requester asked for fee waiver and expedited processing. Basically, the court held that expedited processing was appropriate because it was the kind of newsworthiness, public interest aspect, COVID-19, whether or not the vaccinations were causing any symptoms or anything like that. So it was newsworthy in that regard. The fee waiver was approved of. But what I think the takeaway on this request is that despite the agency's arguments that it just simply didn't have the wherewithal to process a request this immense and voluminous, the court said, well, look, we're not talking about kind of like pages here. We're not talking about, 7.8 million pages of records. We're talking about characters, 250 characters or less, which is a different thing, the court said. And so they said, for example, characters, 200, if every response was 250 characters, that would be about 1.950 with 6 other zeros characters, and that would be about 650,000 pages. And the court said, what, that's not voluminous because it's not unreasonably so. And it still should be processed on an expedited basis because for a couple of things. First off, the court wasn't convinced that the vast majority of the responses were anywhere near 250 characters. It was more like 30 to 40 characters long. The court also noted that the agency itself had said that only about 7% of the free text responses had unsolicited PII, which means the vast majority of those responses could presumably be released without a segregability analysis. And they basically put the agency on a production schedule of basically starting at 390,000 responses a month to be released, then ramping up to 650,000, and then finally 780,000 until they got to the end of the request. So there's whatever lesson you want to take from it, from those two. They're two different courts, two different jurisdictions, but in one, you kind of had what I would probably expect a little bit more in terms of the right v FBI, but then you have this one about the text messages. Maybe it has something to do with the nature of text messaging and the 250 characters or less, but it just wasn't enough for the judge to say, hey, we get it, agency, you don't have the resources to do this. That just didn't matter because what was more important was the agency having to adhere to its mission under the FOIA to release records unless there's an exemption that precludes disclosure, and with respect to exemption 6, to engage in that segregability analysis before disclosure. And it didn't matter that there might be a resource issue with regard to that.
Thanks, Michael. We have 15 minutes left. We might stay a little bit longer for those who are willing to stay a bit longer, but we will try to speed up a little bit for the rest of the cases. Our next is Leopold versus DOD. And I mean, I'll just briefly say, I think this, among some of the other cases that are on the list for today, is a great example of the importance of really having comprehensive, thorough, and well-written declarations. So here, Jason Leopold, who I think doesn't need an introduction, at least to those of you on the government side, he's a pretty well-known FOIA requester. He wanted all media, including videos and other artistic renderings of forced feedings at Guantanamo, the detention facility in Guantanamo. And here the court found that the DOD had failed to describe how its search was adequate for the artistic renderings, because even though it provided some of the search terms, it described the search terms for its initial search, it didn't do so for the subsequent searches. It didn't explain what file systems it searched. It didn't describe what types of searches it conducted, whether it was physical records or electronic records. And it didn't aver that it had searched all likely locations of records. It only said we searched the most likely places, and that's not the standard. So the judge was, very much holding the agency to what the law requires of what the legal standard was. The other thing that I thought was interesting here was that it's a great example also of how courts often give agencies the opportunity to renew their motions for summary judgment. And here the court said, with respect to your responsiveness review and whether the agency had to review every single potentially responsive record to determine if it was actually responsive, and that would have included watching a lot of videos of forced feedings of these detainees. You can go back and have another bite of the apple in your declaration to describe exactly how burdensome it would be to do what the court called an exhaustive inventory of all the records, that is, looking at all of them to determine responsiveness and exemptions, or to look at a partial inventory, a kind of batching, if you will, and pulling exemplar videos and viewing those. That is acceptable as a practice. Courts are okay, if you have a huge volume of records to process, particularly if you can get the requester on board, doing batched or sampled processing and doing everything then in buckets, exemption claims in buckets and so forth. That's okay. It's always better to have the requester on your side, but there's plenty of case law out there. Some of it's mentioned in this case, even if you don't have the requester's agreement. So take a look at that. But again, lesson is, make sure you describe your search well, and that often requires keeping a detailed contemporaneous record in your processing notes of what you're doing.
The next case is the Children's Health Defense versus FDA, and that I will be promise I'll be real quick on this one. This is basically along the lines of the one I was just talking about with the CDC. This was really coming down to whether or not an agency really has the wherewithal to process the request. But in this particular case, what the issue was, there was, again, two jurisdictions. In a different jurisdiction, a different judge, there were two FOIA requests. One got processed by the time of the instant litigation, so I won't talk about that one too much. But the agency basically moved the court in this case for an Open America stay, which Ryan was talking about in the beginning of our meeting. They wanted that 18-month Open American stay because their argument was, look, we know it's not in this court, it's not before this judge, but we have another FOIA request, another litigation where we have a production schedule where that judge in that other FOIA request for that other case is ordered us to produce 180,000 pages a month. And we just can't, and that's why we need this Open America stay for this unrelated FOIA request. The court was sympathetic, as I read the case, to the agency's situation, and because of that, they did grant a 6-month stay pursuant to the Open America, but they declined to do the 18th month. And really, what the court basically essentially advised the agency to do was they said, look, we're not going to second guess another district court. The court basically said, probably not what, it seemed to me that maybe the district court that was presented with this motion was saw that there might be a little bit of a difference between how one jurisdiction might be handling production schedules versus another. But basically they said, look, it's not our job to second guess another court. You agency need to go to that judge in that request if you think there's some kind of excessive production schedule that you can't keep up with. And that's basically the takeaway from that case.
I muted myself, sorry. Okay, next case, Human Rights Defense Center versus Park Police. A disclaimer, I filed an amicus brief at the DC Circuit in support of Human Rights Defense Center, which I would recommend to you. Check it out. It actually covers the main issue that we're going to discuss today with this case, which is clawback requests. So here, HRDC had wanted records from the Park Police about legal actions involving its officers, and the records that ended up being at issue were records that revealed the names of several, I think 3 Park Police officers who had reached settlement in some tort cases, and HRDC really wanted their names. And what happened is, during court proceedings, the Park Police accidentally revealed the identities of these people and filed them onto the docket of the court. A fact which, interestingly enough, the district court really never caught on to. And I think even to this day, not that it matters because the DC Circuit ruled in favor of HRDC, but you could probably still go to the district court docket and find the names of these officers in the agency's supporting declarations when it was moving for summary judgment. The district court, and the DC Circuit said that, first off, Exemption 6 doesn't apply, and the foreseeable harm standard hasn't been satisfied. So the HRDC wins anyway. But what we're presenting this case for is the DC Circuit's ruling that there is no authority under FOIA or under the court's inherent Article 3 power to order clawback. So it's not a particularly common practice, I suppose, but for a long time, agencies have argued that if they accidentally or inadvertently give a requester a record, they should be able, at least in litigation, to ask a court to order the requester to return the record and destroy any copies that they have. Now, at the administrative stage, if this happens, an inadvertent disclosure, the agency's out of luck. There's really no mechanism to reverse the if you will. But in court, agencies have had some success in getting what they call these clawback orders, or what are sometimes also known as protective orders, although they're not really protective orders in the sense of civil discovery. What the DC Circuit said here was, FOIA doesn't say anything, and inherent authority of an Article 3 court is really, first of all, it has to be historically documented, and clawback is not a common practice in the history of the FOIA, but it also has to be tied to the preservation of some other indisputable core judicial authority, like managing the court docket, admitting or disciplining attorneys, holding people in contempt, enforcing orders. Like, all of these things are what inherent or the implied authorities of the court run towards. And clawback simply doesn't fall into that category. Citing, earlier decisions ruling against agencies, the circuit said, look, the unfortunate reality is that mistakes in litigation have consequences, and if an agency inadvertently discloses something, they're out of luck. At least with one exception. The circuit was careful to explain that if there is a very clear independent legal prohibition on disclosure, or I suppose on the possession of inadvertently disclosed information, then there might be grounds for clawback. Not simply based on inherent authority of the court and the desire to, correct a mistake in disclosure, but because there is, again, that independent, legal basis for getting the information back. So classified information, I think, would be an example of that. And then the court also said that they weren't going to address what some of the amici and what HRDC argued were the First Amendment implications of clawback. That the First Amendment means that if you lawfully come into possession of a record, meaning if the agency gave it to you, you're not, it would be an infringement on your constitutional rights for the agency to force you to give it back. So just be aware of this and be careful that you don't let something go out the door before it's meant to, or before you finalized those redaction boxes on your PDF, because you might end up making a big mistake that you'll regret.
Can't put the genie back in the bottle, huh? Okay, so the next one is Louise Trauma Center versus Wolf. This is an attorney fees case. I'll be real quick on this. It's basically a cautionary tale, I guess, for anyone out there listening who is in a position or will be at some point to make a request for attorney's fees in a FOIA litigation. This is just a cautionary tale of a particular requester who had basically the court found that he was entitled to attorney's fees, but based on a lot of evidence that the court kind of noted in its opinion that he was not entitled to get any. Zero. He got zero. And I'll just kind of say the one piece about this. It all came down in the court's mind to this. The counsel, the requester counsel's practice of increasing his fee request following court-imposed reductions to his earlier requests smacks of the kind of bad faith bargaining tactic properly deterred by the denial of a fee award. And so that they can deter future violations. And that's what it came down to. This particular attorney just had a history. The particular judge in this opinion identified the various cases in there, and also articulated about 15 or so different discrepancies in the billing methodology that requester had to substantiate his fee request, and just found it, look, we think we need to put a stop to this practice, and so we're going to, even though you're entitled to attorney's fees, we're going to zero you out on this one because what you're requesting is unreasonable.
Okay, next case is Biddle versus Department of Defense in an Exemption 3 case. And as I mentioned before, here too we find an example of the importance of having good declarations if you're at the agency. Mr. Biddle Sam Biddle requested from DoD's algorithmic warfare cross-functional team records about its use of Google technologies, software, hardware, so forth. And the agency in litigation ended up only arguing that Exemption 3 applied in conjunction with 10 U.S.C. 130E, which protects critical infrastructure security information. And what the court ruled was that the agency had simply not provided sufficient information in its declarations to determine whether or not the exemption applied. Instead, the court basically said that the agency threw a ton of technical jargon into a filing, and I think just expected to win based on some sort of deference because we're dealing with infrastructure security information and vulnerabilities impacting national security. And the court said, look, even the very basics of the statutory standard for withholding here haven't been addressed in the declaration. I don't know what critical information is at issue. I don't know what vulnerabilities or ostensible vulnerabilities are at issue. And I don't know how disclosure would possibly lead to, or would likely lead to, significant disruption, destruction, or damage to critical infrastructure of the Department of Defense. And so the very basic elements of the withholding statute were completely unaddressed by the agency. Moreover, the agency had seemingly dropped all its other arguments for other exemptions that it had asserted at the administrative stage. And so the court said, look, because there might be national security information at issue here, you get another chance, file more declarations, renew your motion for summary judgment, but be sure it's detailed and be sure you argue all the exemptions that you want to assert. And so that's just a general practice rule. Always assert all the possible grounds for withholding the first opportunity you get with that determination letter. Initial determination, set out all the exemptions, and particularly in litigation, don't miss anything when you're at your initial motion for summary judgment. Before we turn over to Mike, to you, since we're at the 3:15 mark, and I know our earlier conversation about Doge and USAID took up some extra time, we're going to keep going. So feel free to stay. We'll finish the recording. So if you do have to drop, I apologize that we weren't able to get through all the cases within the allotted time that we advertised, but we'll make the recording. So once it's live, we'll email it out, the link to our, and check back on our website. So you can catch the last 15 or 20 minutes as we wrap up these cases. But thank you for attending. If you do have to drop, we appreciate your support. Check out our website, accesspro.org. And thank you for all being supporters of the FOIA. But we're still going. So Michael, it's your turn.
Okay, thank you. So the next one is American Oversight versus HHS. And in this one, it has to do with the consultant corollary. And a lot of you probably already are familiar with this case. Basically, in early 2017, House Republican leaders sought to repeal the Affordable Care Act. And while that effort was gaining steam, American Oversight filed a couple of FOIA requests to HHS and OMB, and they were asking for communications related to healthcare reform between each agency and Congress. And so the agencies denied in full those records on the theory that it was intra-agency communication to the extent that the consultant corollary applied. What the court in the DC circuit here did was first they first started with the Klamath case, which we all know about, where the Supreme Court assumed without deciding that some outside consultants could qualify as interagency if the consultant does not represent an interest of his own or of any other client when it advises the agency that hires it. The DC Circuit recognized that post-Klamath decision, which I think was back in the 80s, there are two basic theories. There's the no independent interest, where outside consultants do not have any independent interest in what they're advising the agency. Then there's another line of thinking where it's common goal, where an outside consultant could have an independent interest, but ultimately, because they share an overriding common goal with the agency, that would be enough for the consultant corollary. And in the no independent interest, the DC Circuit observed that the requester would win out on this one, and then in the common goal, or the district court said that the agencies would win on that. So what the DC Circuit did is they took this case was provided them with an opportunity to basically determine what does consultant corollary mean post Klamath. And what they said was they basically went on the no independent interest. They first said that we have only applied the corollary in situations where an outside consultant did not have its own interests in mind. And so the DC Circuit held that the key for the consultant corollary is that the consultant must not have a stake in the outcome of the agency's process that would render its advice on the subject anything other than disinterested. So the inquiry is whether, like an agency employee, is the consultant's only obligations are to truth and its sense of what good judgment calls for. And in this case, the court, recognized that the members of Congress and their staffs brought divergent interests to bear when they engaged with the agencies concerning potential healthcare legislation. And so they found that the report was that the consultant court did not protect the communications between Congress and the agencies in this regard. I won't get into it too much. We don't have time, but I would encourage everyone to read the dissent. I thought the dissent was an interesting read. The dissent basically, I'll just say one bit of this. The dissent said it makes no sense that this same Congress intended to disclose its own confidential deliberative communications with executive agencies while simultaneously exempting confidential deliberative communications sent from one executive agency to another. Nor does it make sense that Exemption 5 would protect a deliberative document sent from one executive agency to another, even though both agencies generally fall within the scope of FOIA, but it would not protect the same document from disclosure if either agency shared the document with Congress, even though Congress is not subject to the FOIA. He goes on, but I thought it was an interesting dissent. But basically, the takeaway for all of us is, the DC Circuit didn't say that communications between Congress and agencies can never be protected by consultant corollary. I think that's important to remember as you move forward in your work. But that the issue you'll be facing with in terms of a consultant core analysis is is there an independent interest that Congress has when it's interfacing with your agency in whatever communications it has. And I do think this is a pretty significant case in that regard. And I would say that every FOIA processor out there would be well advised to closely read this opinion with interest. The next one is Leopold versus Department of Justice. And that one, sorry, find my notes here. This one is basically the Leopold versus Department of Justice is basically, I'll be kind of quick with this one. It has to do with talking points. And, talking points are, we all know talking points. Usually talking points, at least in my experience, they're prepared by junior staff for agency heads or high-level agency folks, the deciders, as it were. And, those are largely protectable, and the court recognizes that in this opinion. In this case, though, they're talking about what was called an OLA 2020 election triage document, which outlined basically potential election day issues. That was the purpose of it, including some hypothetical questions and answers. But the point is that it wasn't junior staff who prepared it. It was a top-down document. And we know that's not necessarily dispositive whether it's top down or down up, but in this case, I think it largely was. What happened here is these talking points were prepared by the top folks at the agency for the purpose of providing the junior staff or its subordinates with what to say, especially if a member of Congress called you on election day. That was kind of this is for. And so the court there said, look, these aren't talking points like you would present to a senior official who may or may not say it. That's kind of why the withholding is something that one could argue is you're able to do, but this is kind of opposite that. This is more telling the folks, maybe not verbatim what to say, but not diverging from the contents of this talking point memo that went out. And because of that, this was final guidance conveyed that conveyed pre-vetted content, so Exemption 5 could not apply to prevent disclosure to the requester.
Okay, we have a string of Exemption 5 cases on the various privileges that I'll and foreseeable harm that I'll quickly go through. The first of them is Smart Flash LLC versus PTO. And this is a processing notes FOIA case. And it's very similar to Machado Amadis, which was one about blitz forms at OIP that went up to the DC Circuit a couple of years ago. Why we're highlighting it here is not because of pre-decisional or the sort of general deliberative nature of processing notes. I think it's well known that communications internal to the FOIA office about how to treat a request or how to decide an administrative appeal are all deliberative because there's back and forth about your impressions and ideas about legal arguments that could be made and the implications of treating a FOIA request in a particular way and so forth. What's interesting here was that generally, one of the kind of rules of thumb for deliberative process privilege is that when you have communications from a superior to his subordinates, it's less likely to be deliberative. And here, I think 5 of the 6 email records that were at issue were from the FOIA lead, team lead, for FOIA coordinator for PTO on this request to his subordinates. But what the agency was able to argue was that even though you had the kind of reverse flow where things would be less likely to be deliberative, it was so early in the stage, he was really only giving his subjective opinions and his input, his recommendations for further steps that his team could take in recommending something for the disposition of the request and the appeal that were addressed in the implicated by the processing notes. So just an interesting example of something that kind of is an exception to the case from, an exception to that general rule that superior to subordinate, less likely to be deliberative. The next case is Pogo versus Department of Justice. This is about attorney-client privilege and about OLC opinions, our favorite topic that seem to keep coming up. Here, Pogo had asked for, I think it was 22 years of lists of all OLC opinions, all OLC opinions. Apparently, there is no such list that exists already in one place. OLC had to find and process annual lists and give them to Pogo. And what it did was it redacted certain titles of certain opinions in these 22 years of opinions. And it said that these sections of the title of the OLC opinion are attorney-client privileged. They're protected by Exemption 5. And specifically, it said that the types of things that we're saying are attorney-client are statute names or statutory sites, or the names of the agencies that requested and received the OLC opinion. And the court said, you're right. That's attorney-client privilege information because revealing the statute that was at issue could, or portions of the title that indicated the precise legal issue that OLC was deliberating as part of its rendering of the opinion, could reveal a confidence provided by the client agency. And revealing the name of the entity of the client agency that requested the OLC opinion would reveal a fact, particularly if it was put together with a date of a time and a subject matter of what the agency was asking for, and plus the fact that it asked for legal advice in the first place, right? So very narrow, or I should say rather broad application of attorney-client privilege, and probably legally correct. The problem in this case, in my opinion at least, is that there was no foreseeable harm analysis, none whatsoever. And attorney-client privilege, as OIPE itself even says, you still have to do foreseeable harm analysis. The burden might be lower, as some courts have ruled, but you still need that analysis, and that was absent here. So an interesting case nonetheless. Next, we have Cizik versus DOD. Here we have a former chaplain of the Air Force. He was passed over for promotion, he claimed, and then he ended up he was separated from the Air Force. I'm not quite sure what that means, if he was discharged or honorably or not, or what exactly happened, but he left the service and he filed a complaint with OIG, and he said that he was terminated or passed over because of retaliation for whistleblowing. Ultimately, OIG determined that was unsubstantiated, and it closed his request for investigation, and he filed a FOIA request to seek a copy of the final report. And here there was really no dispute that the deliberative process privilege applied, or at least the court didn't seem that there was much contest over whether or not deliberative process privilege applied. What it did think, though, was that the agency had really dropped the ball on foreseeable harm. So here's an example of why foreseeable harm matters and why you need to take it seriously. He basically said, and these are quotes, so not just basically, but actually said, the agency had provided a perfunctory parroting of the foreseeable harm standard that was wholly generalized and conclusory, and basically reflected exactly what the DC Circuit in Reporters Committee had said agencies shouldn't do. And that, really there's nothing in the record otherwise to save the agency. So lesson here, take foreseeable harm seriously and don't just parrot the statute. Give a detailed explanation of why disclosure would, not could, but would harm an interest protected by an exemption. Okay, exemption 6, insider versus GSA. I think if you read the description here, it's sort of self-explanatory. This is an older case. Basically here, the requester had sought information about the Trump-Pence exit transition team, and specifically records about salaries for employees. The agency gave records pertaining to higher level employees, but withheld the identifying information for lower level transition members, namely those who were paid under 60,000. I hope nobody's paid $600,000 a year for a transition team. $60,000 a year, and the agency was able to offer credible averments that these type of folks have been subject to harassment in the real world, and they don't even really work for GSA. So revealing information about who they were and what they made and so forth, that sort of personal information, wouldn't shed any knowledge on the operations of the government. So exemption 6 was properly applied there. And then last of my cases is exemption 7A, Leopold versus FBI. This was about the FBI's Mar-a-Lago investigative file, so records pertaining to President Trump's retention of records at Mar-a-Lago. 7A is temporal, so 7A has to do with law enforcement records, the disclosure of which could be reasonably expected to interfere with enforcement proceedings. Again, it's temporal. So once enforcement proceedings are over, the exemption can no longer be used. You need to find something else. And here, the agency had to abandon 7A. The court said it no longer applied. First, because the law enforcement actions against President Trump were dismissed. That's all over. And future proceedings are not reasonably anticipated, which is one way around, right? And why? Because the Supreme Court has said that he'd basically be immune from prosecution. So there could be no further action taken against him or those implicated in the Mar-a-Lago incident, the retention of presidential records. And then finally, the agency had failed to suggest that there was anything post-2020 that President Trump might have done, alleged criminal conduct that would lead to a future enforcement proceeding where the investigative file at issue would be relevant. So for all those reasons, the FBI had to, hand over the records to Mr. Leopold.
So the last two, exemption 7C, McWaters versus ATF. Real quickly, this one is the ATF recovered an audio recording from there was a nightclub fire in February 2003 where 100 people were killed because of the fire. It was a concert in West Warwick, Rhode Island. And the ATF recovered at that site an audio recording from the body of a deceased concert goer who inadvertently recorded, the moments surrounding that event. And the recording can be divided into 3 parts, but the one that's important for this case is the last 8 minutes, and specifically the 4-minute portion of that recording. So a 4-minute portion of that recording where human sounds are audible on the first 4 minutes of that final 8-minute segment. So human sounds are audible in that portion, and the ATF withheld that under exemption 7C because the privacy interests of the surviving family members of the deceased who can be heard on the final segment of the recording, they have a right to personal privacy with respect to images of audio of their close relatives' final moments. So the court found that the exemption 7C withholding by ATF was appropriate. They did obviously engage in the balancing where you had the weighty privacy interest on the one hand. Well, what's the public interest? There wasn't any. The plaintiff, the court said, just simply restated its public interest, if it is one, that to quote, evaluate ATF's investigation and resulting report of the station nightclub fire in order to facilitate better fire investigations and fire safety recommendations. The court saw that as just the requester seeking information for its own sake, and said that that really what the requester was doing is he expects to find something in the tape that ATF missed. And therefore the plaintiff's speculation is insufficient to state a significant public interest. I thought this part was interesting. If that weren't the case, the court said any law enforcement record would serve the public interest because it too would allow the public to quote unquote evaluate an investigation and resulting reports. So 7C was appropriately applied to that portion of the recording. The last case then is 7E. This, I think, even though it has to do with exemption 7E, I think it's kind of a foreseeable harm case, kind of what Ryan was touching on before as well. And that is that the IRS has an internal revenue manual and a particular section, they withheld parts of it. Section 21.1.3.3, Internal Revenue IRS manuals can get pretty precise. And so they redacted certain parts of that, and the court found that the use of exemption E to withhold that was appropriate because it reflected, after an in-camera review, techniques and procedures for law enforcement investigations and prosecutions. What was interesting for the case, and I think what the court did in this case, is they analyzed the language as exemption 7E. So they said, okay, 7E has basically two parts. It has your techniques and procedures for law enforcement investigations and prosecutions on the one hand, or, there's the word or is there, or guidelines for law enforcement investigation prosecutions if such disclosure reasonably can be expected to risk circumvention of the law. So what the court addressed was, well, does circumvention of the law apply to the techniques and procedures or the guidelines or just one or both, what have you? And so the court there found that based on statutory construction, the risk to circumvention of the law, that applied only to the guidelines, not to the techniques and procedures. Therefore, the circumvention of the law is presumed for that first part, the risk of it. But kind of almost didn't matter because you have to go into a foreseeable harm analysis anyway, which is what Ryan was saying in the other case. And so, of course, we all know the test there is would disclosure would foreseeably harm the IRS in preventing the circumvention of law. So what could the IRS show that it could say would foreseeably harm it? And what the agency did is basically argue past this prologue, because it said, look, we implemented these third-party authentication procedures that we're withholding that the public doesn't know about because there had been instances where there were certain breaches and circumvention of certain confidentiality or that kind of thing going on. And so the agency implemented these techniques and procedures to put a stop to that. And so releasing this information would result in basically reverting back to what they were trying to prevent, which was this circumvention of the law of basically folks trying to impersonate certain taxpayers and that sort of thing. So the foreseeable risk was, the foreseeable harm was successfully articulated. But interestingly, I guess just the last point on this is the court basically said, look, if part 2 of 7E that has to do with expected to risk circumvention of law, which the court identified as a minimal burden because it's just expected to, it's not that would foreseeably harm standard of foreseeable harm. Does it even matter anymore? If you have this foreseeable harm independent standard that you have to apply, even if you succeed on 7E, either prong 1 or 2. If you have, for example, guidelines and you have withheld those guidelines under 7E, do you have to meet the lower risk circumvention of law standard that's within the 7E language? Or do you have to adhere to the higher foreseeable harm standard? Well, you have to adhere to the foreseeable harm standard. It's an independent standard. And so the court did mention that, as a result of that foreseeable harm standard, for whatever it's worth, the circumvention of law risk language may not really be much of a standard at all, given that the higher foreseeable harm would necessarily apply to either one of those when withholding a record under that FOIA exemption.
Well, thank you, Michael. And I apologize again for going over, but we still have quite a crowd who stuck around. So I hope that this was helpful presentation to those of you who did stick around. I don't know if I mentioned it at the beginning, but I will again now. ASAP has been around for 45 years, since 1980. And, our goal is to bring these sorts of trainings, not only to those in the government who are information specialists and attorneys practicing FOIA for the federal government, but really to bring this material also to the requester space, to civic society, and to just the interested public. So again, please check the link for all of the citations and summaries. Feel free to send us a question if you have one. We'll be posting the recording. Michael, thank you for joining me today for this presentation. And Claire, our executive director, thank you for helping make this town hall a possibility. Join us again the next time we have a webinar. Check out our website, accesspro.org. Claire, do you have any closing remarks? Oh, you're muted.
Just wanted to thank everybody for their participation and joining in today. So, and happy Sunshine Week.
Happy Sunshine Week.
Thank you for your time. Thanks a lot.
Thanks.
Bye, everybody.
Bye-bye.
Bye.